Honor. My name is Taylor Hooven on behalf of my colleague Dakota Derrick, who represent plaintiffs Harry Young and Lansing in this matter. Your Honor, before you today is the damages aspect of this case. Defendant Hospital committed statutory battery when doctors at the hospital illegally removed a kidney from a minor child. Your Honor, as I said before you today, is only the damages aspect of this case. Likewise, my colleague Dakota Derrick has certain housekeeping motions to bring before your attention, and also have some substantive motions if you would entertain them too.
All right, we're going to start with the defense's housekeeping matters first.
Your Honor, first of all, pursuant to Rule 615 of the Federal Rules of Evidence, as well as the stipulation 16 in this case, we would ask that all witnesses be constructively sequestered.
Are there any party representatives that should not be sequestered?
Yes, Your Honor, there are. For the plaintiff's side, Harry Lansing will be our party representative, and we also have an expert in this case, Dr. Charlotte Skinner. We request as an expert she not be sequestered.
Okay, does the defense have a party representative?
No, Your Honor, but we do have an expert, Dr. Sabat.
All right, so does that leave only one witness who will be sequestered?
Yes, Your Honor.
And who is that?
That's Reese Lansing, Your Honor. He is the person whose organ was removed in this case.
All right, so we will sequester that one witness. Any other housekeeping matters?
Your Honor, simply where would you like exhibits placed once they've been entered into evidence?
Over here with the constructive court reporter.
Yes, Your Honor. And I also have a few substantive matters at this time.
All right, do you have any housekeeping matters?
Yes, Your Honor. First, the plaintiff wants to confirm that South Texas is a standing jurisdiction and we have permission to move freely about the courtroom.
You do.
We move for all witnesses to be constructively sworn in before testifying.
They will be.
We want to confirm that if any arguments arise over a piece of evidence, that those arguments will be constructively held outside the presence of the jury.
If there is something that you want to be heard outside, please ask for it to be heard outside the presence of the jury selectively.
And finally, Your Honor, what is your preference for asking to approach a witness?
You ask every time you approach a witness.
Thank you, Your Honor. My partner, Mr. Hooven, also has several substantive pretrial motions.
Okay, and what are those?
Your Honor, first of all, before we get started, I have a copy of the pretrial conference report, complaint for damages, and the order granting partial summary judgment in this case for your review if you'd like to see them.
Have you shown opposing counsel these documents?
I believe I have, yes, Your Honor.
All right, you may approach.
Your Honor, if I could call your attention to certain stipulations that we'd like to read to Your Honor and into the record. First of all, stipulation number 10, the parties have stipulated that Neil Sampitt, Taylor Warren, Maggie Jordan, Don Kiefer, and Jenna Johnson are unavailable for purposes of Federal Rule of Evidence 804 and may be called by deposition. Additionally, Your Honor, number 11, the parties have stipulated that the expert reports and resumes are admissible. And additionally, stipulation 13, exhibits M through Y are original and authentic. Stipulation number 14, neither party has challenged the qualifications or methodology of the other side's expert witnesses. No further objections to their qualifications or methodology will be entertained. And finally, number 15, each expert's qualifications and methodology meet the standards of the Federal Rules of Civil Procedure. Attorneys need not tender the expert. The expert's depositions are admissible in whole or part under Local Rule 5.003. And now, Your Honor, we chose to read these because they are germane to our case here today, but Your Honor, there are also other stipulations that we have not read today that we will call to your attention as they become necessary.
I understand. Now, does the defense have any stipulations they would like to read into the record?
Not at this time, Your Honor.
All right.
Your Honor, pursuant to stipulation number 10 and the names we just read, we request and move that all unavailable witnesses' deposition testimony, those who are able to be called by deposition, have their depositions read constructively in their entirety to the jury. But for the sake of time, we will only call by deposition testimony only 2 witnesses. We have made those depositions and the portions that we wish to read in real time available to opposing counsel.
Response?
Your Honor, that's fine with me. I would just request that I be able to object to any deposition testimony. That would be the same as I would object to a live testimony.
And do you have any response to allowing objections during these testimonies?
No, Your Honor, we do not.
All right.
All that.
Granted.
Your Honor, also, finally, we remind Your Honor that South Texas' collateral source rule observes the collateral source rule, and we move to exclude any reference to with insurance or insured costs today.
Any response to that?
Your Honor, that's fine. Our expert, Dr. Sabat, does have calculations that are based partially on considering whether or not insurance would be available. However, as Your Honor is aware, pursuant to the Federal Rules of Evidence regarding expert testimony, an expert is allowed to give their opinion without discussing the bases of their opinion, unless opposing counsel would like to bring that out. And so as such, I will only ask Dr. Sabat his opinion without going into the insurance issue.
Okay, so there'll be no mention of insurance by either side?
That's correct, Your Honor.
All right, then that's granted.
Thank you.
Anything else?
Nothing further from the
And
plaintiffs.
from the defense?
Yes, Your Honor. I believe that opposing counsel has handed up a copy of the complaint. In this case, Your Honor, we moved to dismiss for lack of subject matter jurisdiction. As you can see on page 2 of the complaint, it states under number 10 that the jurisdiction is based on diversity. However, nowhere in the complaint does it allege that there is an amount of controversy greater than $75,000, and as such, we would move to dismiss.
Response?
Your Honor, the projected damages, future damages in this case are in the millions of dollars, well above the required $75,000 statutory minimum.
Any response to that?
Again, Your Honor, it's not listed anywhere in the complaint, and there are no verified affidavits to support that amount.
All right, I will deny that motion. Anything else?
Yes, Your Honor, I also move for partial summary judgment as to the exemplary damages. They are listed on page 4 of the complaint, and I believe in paragraph 15, and again in 16. However, Your Honor, they lack specificity, and as such, should be denied.
Any response to that?
Your Honor, in South Texas, exemplary damages may be awarded by a jury if the jury so believes they are merited in a certain case. Your Honor, as such, they do not need to be specifically pled, only alleged in the complaint. It's for the jury's determination as to how much, or even if exemplary damages should be awarded at all.
So why aren't they to be specific?
Because, Your Honor, it's a jury determination. There's no real amount other than what the jury decides or believes favorable or even allowable in this case.
All right, I will deny that motion. Anything else?
Nothing further from the defense, Your Honor.
All right, are we ready?